So,
hey, good afternoon. I'm James Vann. This is Jim Beck, and we are really thankful that you're part of this webinar today. We're going to be talking about collection efforts in commercial accounts. Just so you know, just for homework efforts for everybody, if you have a question, you can use your GoToWebinar control panel and submit that question that way, or you can send us an email at webinar@vannattorneys.com. Also, mark your calendar. We're going to have our next webinar on April 15th at 3 o'clock. The topic, we've got to decide on that. So if you have a topic, let us know. And a really special thank you to a friend and client of ours. I'll just use his first name, Mark, came up with this topic that we're covering today. And Mark, it's a huge success. We've had probably more people sign up for this one than we have many others. Even though we usually have a really good crowd, this is a really good one. So. One other piece of homework for today, that is, if for some reason we lose power due to storms, hang in there. Don't sign off. We've got a backup plan to reconnect it. So just hang in there with us. So hopefully that won't happen. So we're going to be talking about collection efforts, and we're going to be looking at best practices. So again, hopefully this is helpful. We're going to be looking at some do's and don'ts. How do you connect or contact your commercial customers? What can you say, right? What do you not say? And then we've got some other tips that we're going to share with you. So really to first get started is to look at what regulations apply, right? And how, I mean, Jim, that's something that we deal with a lot, and it's either consumer or commercial. And in commercial settings, it's the FTC, right? That we don't have to worry about, thankfully. FTC, which is the Federal Trade Commission, regulates consumer debt and how that's collected. And Jim and I have been practicing law together for quite a long time. Thankfully, we don't really deal with consumer debt.
fortunately not. There's a lot of regulations that really restrict what you can do, and you gotta be really careful with consumer debt. And I think importantly, for purposes of this, it's really necessary to kind of explain the difference. How does a client know if it's consumer debt or a commercial debt?
So walk us through what consumer debt is. How do you define that?
Well, it really is if the obligation arises from something that's for personal use, family and household use, that becomes a consumer debt. So maybe would that be like a credit card debt for purchases of something from Target? Maybe.
Could be. What about if it's office supplies, though?
Office supplies, I would tend to think that's a commercial debt. It's for business purposes. It's a little different. What if they're a little bit of each?
How does it apply?
Let's think here. If a little bit of each, do we err on the side of being careful?
Yes. There have been times when we've sent out a demand letter where most of our clients are in the commercial setting, for almost 100%. But sometimes one of our clients may deal with an individual or consumer. They're not incorporated. It's for their, let's just say, for example, they're buying an appliance from one of our clients. They're buying all of the appliances for their house, right? Refrigerator, stove, oven, all that stuff. Is that consumer or is that commercial? It's probably consumer.
It's probably consumer. Yep.
Let's say, for example, that customer is also a builder, right? They also they're a general contractor, and they buy it under their company name, but it's going in their personal home. Does that matter?
I think it does.
Which one would it be?
I'm going to err on the side of consumer debt.
See, I'm going the other way because the commercial customer bought it, but he's going to put it in his own home, or he or she's going to put it in a home.
I don't know.
You see the challenge.
It ain't always that easy.
It's not always that easy. But the consumer debt guideline that you see on your screen, it's any obligation of a consumer to pay money arising out of a transaction. The key is primarily personal, family, or household purposes. So let me ask you this. Let's say, for example, that we've got a truly commercial debt, right? It is squarely, there's no question that it's commercial. But you have an individual that signs a personal guarantee, and you start collecting after the personal guarantor. Does the consumer debt stuff kick in?
I would say no.
Yeah.
Because it's still for business purposes.
Yeah.
They just guaranteed it.
Yeah. So hopefully that helps y'all. And hopefully you're not in consumer debt. that would not be a good idea. So if we can get, I'm gonna try that for some reason. There we go. All right, some do's and don'ts, right? So this is just to base off some case law and some just common sense, hopefully. Avoid deceptive text or communications, emails, however you communicate. Be honest, obviously, but avoid the deceptive text, emails, and communications. Be truthful, and be also careful what you say or write. I mean, I can't tell you. So, Jim, when you take a case and you're doing discovery, what's the first thing you start looking for that you ask for, right?
Well, correspondence.
Show me right.
Yeah.
Show me what's written, right? That could be handwritten. It could be by this thing right here, which can be really good. It can be really bad. It's all over the board right now. It's text, it's emails, it's paper letters if they have those.
I'd say the text aspect of it nowadays is probably the most dangerous because there's a lot of emotion. You're sending a text, and I've seen angry people, and keep it professional because
Absolutely.
I've seen pretty much everything you can think out of a text, even though it's a business communication.
Yeah. And I think for some reason, most people, when we grab this, right, to send a communication, for some reason, our brains don't consider this to be as formal as it is if we're using our computers or laptops or whatever it may be, right? So we got to be really careful, I think, in that respect. Also, identify yourself truthfully, right? Say, hi, I'm so-and-so, I'm with such and such company, and I'm the I'm the collections supervisor, whatever your title is, credit manager, and I'm calling about blank, whatever that is. Make sure you identify yourself. So Jim and I were laughing about, before we got started, about the prank calls that used to happen before caller ID really happened. I mean, it was so much, you could have so much fun doing that. And I know a lot of times people would call in commercial collections, I don't know about consumer, but collections, and they're just trying to see if somebody's at their office, right? They wouldn't say who they were because they want to make sure they got them on the phone. Is that wrong? Probably not necessarily, unless they're being deceptive, right? I would say. And even then, even in a commercial standpoint, you probably don't, that's not probably actionable.
Yeah, I mean, there's a line, but I don't think that crosses it.
Yeah. If you're calling 10 times in an hour and you're not identifying yourself, then that might be a problem, right?
That might become harassment or something. Right. What about leaving a message? I mean,
again, I would say who you are, the company you're calling from, and who you're trying to reach, and then that's it.
Right? I think the problem is, a couple of problems, is that sometimes you'll get a voicemail. If it's a cell phone, it'll half the time not even identify a person.
That's right.
It'll say you've reached 919, 123, and then doesn't say a name. Right. So who am I leaving this message for?
Yeah.
So, and if it's a old kind of fashioned, just a voicemail on a landline, again, you don't know who's going to get that voicemail. So leaving account details on the voicemail, don't do it.
Yeah. Be really careful what you say in that. And so in a voicemail, we would encourage you just to say, hey, look, who you are, the company, and I'm trying to reach, Bob Smith. Please call me as soon as you can. My number is so-and-so. And then stop right at that. What about revealing dead information to third parties? Should that happen?
I think that's information you've got to keep protected so you know who you're.
Yeah.
One, you've got some obligations and you to not release information that is, protected. You just need to make sure you know who you're talking to.
Yeah.
I mean,
if you're calling, let's just say you call, and this happens to us a lot. We have a company that we're trying to collect money from, and we have a personal guarantor with it. And then the spouse is not on as a personal guarantor, and we don't even know if the spouse really has anything to do with the company. And then the spouse calls and says, hey, look, my husband or my wife said for me to call you. They got your letter and they want to pay, right? So we can talk about it. I don't think I generally avoid that. I'm like, I'll call back.
I'd probably ask for some kind of written okay.
Yeah.
If you get an email from the person who's involved in the business that says, yeah, it's okay to talk to her, that's different.
That's right.
So
get some kind of communication from them that you know who it's coming from, not from the spouse that is not on the account. But you don't want to disclose that information. And, it's tough because you want to talk to them because you want to make sure that you're getting hopefully information that they'll get the account paid, but you also don't want to disclose information that you shouldn't be disclosing. So there's one more tip right here on this screen that says that we said, do not threaten criminal prosecution with civil gain. And what that means is this: what you don't want to do is, if let's just say you get a check that a customer paid you, and the check bounces, and then you call the customer and go, hey, we got your check. If you don't get this thing paid, right, I'm going to turn you in. We're going to lock you up. We're going to have you arrested for passing a bad check. And they'll say it's $50,000, so it's going to be a felony, right? You're going to spend time unless you pay me. That's threatening criminal prosecution for civil gain. What I think you can say is, we got your check, it bounced, and we're going to pursue every option possible, which may include criminal prosecution if you don't get this paid. Did I say the same thing? Probably. But I'm not threatening criminal prosecution for civil gain. But I'm saying we're going to include everything possible, which would include criminal prosecution. And there's actually a case that came out that said that's actually softened that a little bit. But I don't want anybody to walk off from this thinking, well, I can threaten criminal prosecution. And so don't. It's just, you want to avoid that by all costs. So hopefully that makes sense. So what are some other do's and don'ts, Jim, that we think we ought to look at?
I mean, I think this is a good one. As soon as the account goes past due, reach out. And I mean, there's a ton of reasons for that. They could be leaving town. They could be getting ready to file bankruptcy. They could be doing it. Who knows what they're doing with their assets? But it could just be a mistake. And if they're a week late, oh yeah, I forgot to pay that. Well, you wait 2 months, and then now they've got other debt building up. They got interest on your debt building up. Just makes it harder.
Stats will tell you the older it is, the longer it is, and harder it is to collect it. It's just statistically proven. So move quicker, right?
Yeah, emotional conversations. Well, a lot of times customer is going to be upset. You're armed with the facts. Don't get into a yelling match. Just, these are the facts. You sign a contract, you owe us this money. Stay professional.
That's right.
That's pretty easy.
Yeah.
Don't get riled up. Make it easy for your customer to pay. And offer a suggestion. You can send me a check. I can come pick up a check.
Yeah.
I'll give you my wire transfer instructions.
Right.
Here's we can take a credit card. The easier it is for them to pay, and to not be able to make an excuse about, oh, I can't get you a check by this date. I got to go to my bank. I've got to, do this or that or the other. Make it easy. If they say they can't get to their bank, say fine, I'll come to you. Or here's a credit. Send me your credit card information.
And I know a lot of our clients now have a whole host of tools to be able to take in funds, right? They can do it online. They can do it by credit card. They can do it the scan check kind of thing now by fax or whatever. And, it's just payment now. Like you say, you got to press on those to get your money. Right? And that's a good thing to do.
All right, so they hang up after saying, I'm going to pay. Okay, you're great. You're waiting a couple days and you still haven't seen it. Falls off your radar. A month later, you say, oh, that customer was supposed to pay.
Yeah.
Maybe set a reminder on your phone for a day later.
Yeah.
Follow up. Just keep following up with them until you actually see those funds.
Yeah, that's a good point. And then just make sure, I know a lot of our clients, if let's say the customer says, I'm going to pay you on Friday, the 15th, they'll call them on Thursday afternoon, the 14th, and say, hey, look, we're looking forward to that payment tomorrow. And we do that a lot when somebody says, I'm going to pay something on behalf of a client. We'll call them that the day of or the day before and just say, remind them. And I had that happen this week. And this guy is just, he has more excuses than you can ever imagine. So I called him the day before. I was like, are you going to make the payment? He's like, well, and he started coming up with some, I don't want to say the answer, but a bad answer, right?
Right.
And I told myself, well, you know what? We're just going to go ahead and sue you because he's lied so many times. We just know he's lying. And he is, right? But we try to follow up ahead of time. So anyway, hope that helps. What about a sample call?
Sample call. Well, here's a easy format you can follow. You know, identify yourself, who you're with. You know, explain what is due. Be specific. You haven't paid these invoices or this statement. Here's the amount. When can we expect payment? And just make it as clear, concise as you can, and just ask for the payment, and not in an adversarial way, but we're waiting on the check. Can you let me know when it's coming? And then kind of put it back in their court.
Thing I have found out over my years in doing this is they usually know why you're calling, right? And as soon as you identify who you are, why you're calling, and sort of the purpose of it, which is very brief, I generally will stop and I'll say, how do we get this paid out in full? And stop. And there's silence, right? I'm okay with silence. I can deal with that. And you can say, when can we expect to get the payment of the past due amount? And just stop. What I would love, I wish we could have open this up for everybody to answer. Like, what question do you ask, right? Throw it back in to the debtor to say, when you making the payment?
Yeah.
So you got any insight on that? How do you do that?
I mean, there's probably 10 ways to do it, but I think the key is telling them what they owe. You can even offer to provide the invoice again.
Right.
Or we'll send you the invoice again if you're missing it. But before you're done talking, I think you just need to throw it back and say, when can we get a check for this, or however they pay?
This is a little bit different than the collection effort, but I say this to you in this respect, because we just had a mediation a while back, and the debtor had signed a promissory note, and the debtor had just avoided it and just ignored it with our client, and our client hired us to collect the money owed. And in the mediation, and the debtor is going to be paying our client, and thankfully it started, but we just knew, based upon how our client had told us the debtor had dealt earlier, that if we didn't put specific dates and times of payment, then there was going to be a problem. So we made certain in the settlement agreements that say, for example, the payments made on the 1st of each month, and we said it has to be received by our office before 5 p.m. on these dates, because we knew they would say, well, we put it in the mail, or we sent it overnight, or whatever it may be. So I don't care if you hand deliver it, bring it by carrier pigeon, I don't care. You can wire it. That'd be great. If you don't do that, and if it's not here before 5, you're in the fault, period. I don't care. So this was the 1st of this month, I think. She showed up at 4:55 with a check. Kid you not. I'm like, wow. If traffic had called her in a different direction, she'd have been in trouble.
Yeah.
So anyway, that's just give you a little tip. So what are some other phrases you think?
Well, it's okay to explain the terms. You know, we want to make sure you're going to stay current. So if you have, let's just say you've got a customer who, you know, they've been late in the past, or you're kind of concerned about them for whatever reason, maybe call them even before it's due and say, you got this invoice coming up. We just want to touch base and say, you know, we want to make sure you're on schedule to get that to us by whatever date. And if you need the amount, need a copy of the invoice again, let us know.
Yeah, makes a big difference. And I know a lot of these tips we've talked to you all about. So what you see on the screen is an example of what not to say. So I was telling Jim about this, and he had helped in this case a little bit too. We had a client who provided some construction materials to his customer who was doing work on a house, and he had provided a lot of materials, right, and hadn't been paid for it. So his company, he himself, filed 2 different liens on properties, and they really messed it up. I mean, the liens were just not correct. They didn't mail it out to their customer. It was just a mess, right? So after they did this, somehow or another, a collection agency picked up on the fact that he had filed these 2 liens. The collection agency contacted our client and said, hey, look, we know this builder and we've collected from this builder before. We'd love to represent, we can get you money quickly. And our client was like, go at it, get on it. So what you see here is an example of an email from the collection agency to our client's customer. And it says, I've left numerous messages for you, no response. This time we're moving forward with a foreclosure of lien against both properties. Well, there is no real phrase of foreclosure of lien, right? That doesn't matter, right? And it says we need to meet with you at the property and the property owners tomorrow to recover the unpaid materials from the property, which is a problem. And because in North Carolina, you cannot go and remove materials or supplies that have been built into or added to or connected to a structure. And if it's sitting on the ground, as long as you're not breaching the peace, you can go take it. But this was actually stucco.
You can't take somebody's front door.
If it's hooked on the house, no. If it's laying on the front door, or
that would be a good way to get them to pay that.
It would be, take the door. This was stucco, and I'm thinking, obviously the collection agency did not know what it was, because you're not going to go scrape the stucco off the house. And then the collection agency continued to communicate with our client's customer to say, hey, look, we're going to proceed forward. Here's another email to them talking about that they were going to use these attempts. It's been futile. They've got documents on their desk to file a foreclosure of lien on behalf of my client. These will be faxed at 10 o'clock a.m. tomorrow morning to our attorney. The foreclosure of lien is to be filed for $25,596 plus filing fees, blah, blah, blah. And they say, that at this time, so-and-so is acting as authorized agent of the client, and they'll accept $20,000 in full and final settlement. None of this, quite frankly, that our client approved, which that was interesting later. Once the funds are confirmed and considered, then they'll release the liens. Well, this email got the customer all bent out of shape, so he went to his lawyer. The lawyer found the liens and immediately filed a lawsuit against our client because the liens were so bad. And our client hired another law firm in the state. They dismissed the liens, but the lawsuit was not canceled. They didn't end it because he wanted attorney's fees out of it. Well, our client said, I'm not paying attorney's fees for this, right? You're not out of pocket anything. So eventually the client hired us because they couldn't negotiate. The other attorneys were not having much success in negotiating it with the general contractor's attorney. And then both our client and who is an awesome business person and really good guy, got a little bit bullheaded, and so did the general contractor, and neither one of them wanted to back down. And I don't blame our client. I mean, he was getting raked over the coals because the dollar amount that they were alleging kept going up for the attorney's fees. And by statute and case law, you can't have a lawsuit just for attorney's fees in that context. We had a half a day, 3/4 of a day trial on this thing. Thankfully, we won. And we actually got a little bit back from the opposing party in cost, and not necessarily as much as attorney's fees as it was cost. But the gist of this story is this: the collection agency took actions that were really wrong, right? And they said things that it's in the commercial setting, but in some respects just did not set well, right? They didn't violate the law, but what they did do was they got our client in hot water, if you will, from the other side, and nobody wanted to back down. But some of the things he said were just not factual, right? They did not have the documents drafted. They weren't ready to file it. And there is no, in North Carolina, foreclosure of a lien. There is a lawsuit to enforce it, but the reason we bring this up to you is it's just a great example of making sure you're honest. Because when you look at the letterhead, which I had to take all off because otherwise you know who it was, it looks like a law firm. It looks and smells, and it just looks like a law firm. And the words this guy used sounds like an attorney, right? You want to make sure you avoid that kind of stuff. So hopefully that makes sense. So how do you contact your commercial customer. What do you think?
Any way you can.
Yeah, that's right.
Call
That's
them.
exactly right.
I think phone call is probably the primary way. Get them on the phone and have a conversation.
Yeah.
A lot of times, emails and text messages not only they lose context, but people can misinterpret. You know,
Oh, yeah.
are we going after them aggressively and adversarially, or are we just trying to discuss ways to get the account paid?
Mm-hmm. Yeah.
You know, it's okay to send emails and texts and even a letter. Make sure the tone matches what you're going for. I mean, sometimes you need to be aggressive and pushy, and you had better make a payment. And sometimes it's just, hey, where's this payment? Because maybe it's a customer you've had a long time and they just, you know, they missed one,
Right.
missed a couple. So always think when you're communicating what tone you want.
Yeah.
I think that's as important as the method of contact.
Yeah. You know, one of the ways we have on there is text. So we got a question ahead of time, which was really helpful, and we appreciate that so much. The question was that, you know, using text by business phone to inquire about payments, is that lawful? And it is. There's no limitation on that, which is really good. So can you text with your customer, your client, or your customer for payment? Absolutely, right? But again, be really, really mindful about what you're texting, because it's no different than if you put it on letterhead and send it, right? It's going to be admissible. So if someone else asks a question, are texts admissible in court? So what do you think? What's the answer, Jim?
Well, I would say they are.
They are.
I think the key here, treat your text as any other business communication.
Mm-hmm.
Just because you're sending a text, you don't have to shorthand it,
right,
or you know, be casual. You can still send, you know, professional text about payment. The other thing I was thinking about is make sure you know or are comfortable with the phone you're sending it from.
Right.
I mean, I don't know if you want your personal cell phone, not only because want to use your personal cell phone, not only because the customer then has your personal number, which you may or may not want, but when you get into a litigation and they want to see all communications from any device you've used to communicate on this account, there may be some personal information that
you don't want
that now becomes discoverable.
Yeah.
And I don't know that I'd want that out there unless I'm just using that phone for business or whatever.
So you mean to tell me that you can have a personal phone and a business phone, and that's okay to do?
I think that's all right.
I do too.
Yeah.
Despite what some people in public life have done in the past, I'm not saying who, but anyway. So we had another question that had someone said, "Hey, look, can I, if we have text, is that admissible in court?" The answer is yes. And I will tell you, most of the time now in discovery, that's included, right? It's form of communication. It doesn't matter what it's on. And I talked to a client yesterday who sent us a question. I called this person back. I said, "How do y'all do it? Because I know there are databases. There's ways you can do it through your computer and communicate with anybody, right, on their cell phone, or do you actually have a cell phone?" This client actually was using a corporate cell phone for the collections or for commercial purposes, right? Just for it was not that client's personal cell phone, which is probably, like you said, it's a whole lot better from a discovery standpoint, right? Because when you ask, "Hey, look, y'all have any communications by cell phone with your customer?" If that happens, most people don't start thinking, "Did you do that from your personal phone or did you do it from a business phone?" So, and you don't want that stuff included.
I think there's a question about the manner of producing too. I think it was you just screenshot it. And that's the only way I've ever been able to figure out how to do it.
Yeah.
And I've never had anyone complain about it just being a screenshot. I don't think there's an easy way to produce texts. So I think it's generally a screenshot.
Yeah.
You just screenshot each text, and it's kind of tedious, but you got to do it. So.
Thankfully we have one of our team members who helps us with it from a technology standpoint, but just download that stuff. But you're right, it's not fun and easy, but it's certainly a lot of times that's how people communicate now, right? And certainly by emails. We won't go through because we've done seminars or webinars on electronic transactions, but using your cell phone, even in counting voicemails, it's electronic transactions or electronic communications, which is discoverable. So if you leave a voicemail, it's there, right? And a lot of y'all probably have this where voicemails now go to email, right? So you think about it, it's going to come up in that way as well. So be careful what you say, even in your phone calls or your voicemail, if you're having communication back and forth, even if it's the person you know, because it might be discoverable. It's not take back. It's going to be.
Well, that works both ways because maybe you get a call.
That's right.
From the customer that's helpful.
Yeah.
I know I owe it.
Yeah.
It hangs up. It hangs up.
Yeah.
I mean,
that's right.
So it can go both ways.
All right. So let's look at the next one. All right. So we've got a poll question that we're going to be popping that up. So hopefully you got to see that on your screenshot coming up, I hope. Hopefully we'll see that. And then so our technology guy that's helping us with it, I'm trying to figure out how we're going to communicate with him on that. All right, so we've got this coming in. So the question is, in the last year, which of the following yielded a better collection result with your customers? So hopefully you got that, and then we're going to close the voting opportunities, and we'll see the numbers. Hopefully, I don't know if we get to see that or not.
I hope so.
So phone calls, emails, texts, letters, or all of the above. Which one works best for you? So we got 60% of y'all that voted. Thank you for doing that. All right, so Michael is doing magic work behind the scenes to tell us. So he's given 5 more seconds on it. So 70% voted. Numbers moving. That's almost like election, like Jim. So
right.
You got any projections?
I do not.
All right, so 70% voted. So 32% says phone calls, 52% says emails, 4% say text, 4% letters. So again, phone calls and emails, or emails is first, then phone calls, and then 8% say all of the above. So hopefully that helps y'all understand a little bit as far as how other people use it. Certainly, email is. I'm actually a little bit surprised that that's still as high as it is, but 52%.
So I'm thinking, if you owe somebody money, you don't want to talk about it.
Right.
Emails is a way to.
Yeah.
Okay, I don't want to get in a conversation about this, so I'll just shoot an email.
Yeah.
And maybe they can buy some time, but it's good that that's actually working and you're getting responses.
That's right.
I hate to send an email and then never hear back. So
yes, and 32% said I think phone calls, right? So and 8% said everything. So what's some suggestions for phone calls? How can we help with that?
Yeah, well, let's get the right person on the phone.
Yeah.
We want to make sure when we're calling somebody, obviously we know who we're going to talk to.
Right. Yeah.
So if you got a direct dial, that's ideal because, generally speaking, no one's going to answer somebody else's direct dial.
Right.
So use a direct dial if you've got it. If you're having trouble getting somebody and you keep getting voicemail, a lot of those voicemail systems you can divert away from the voicemail, get a person, have a conversation with the receptionist, and either leave a message that way so you know someone actually got that message, or maybe she or he will end up directing you to the person. Call at different times of the day. Maybe there are times when that person just doesn't answer the phone. Some people have a very specific schedule they follow daily.
Yeah.
I like this one. Use different phone numbers to call from because they may have your specific number and they're seeing it on their ID and say, well, I don't want to talk to that vendor. I know what they're asking me for.
That's right.
So maybe get them on the phone by calling from a number they don't know.
Yeah.
And then if you got a cell number, that's good as well, because again, no one's going to answer somebody else's cell phone.
Generally speaking, that's right.
So, if we're trying to get a specific person on the line, those are probably your best options.
Yeah. So we had a couple of comments from folks talking about how you take screenshots and delete out the contact so that it shows the actual phone number. And then somebody else had sent in a comment that says email is date stamped, which is correct, and it's very helpful. This person says found to be extremely useful, and you're exactly right. I mean, I can't tell you how many trials or motions we've had when we say, let's look at the date stamp and the time stamp, right? Because certain things happen in certain time periods, right? And you look at that. I mean, it's key, right? Sending an email really does matter.
Yeah.
Right. And it's written, and thankfully it is date stamped.
And I think those communications are often more formal. I mean, emails as opposed to, I've got a note in my journal that I left in my voicemail.
Right.
It's harder to document.
Yeah. And then I also would say this: if you're calling and leaving a message to somebody who's just avoiding you, and again, I'm not sure where this would fit in necessarily from a legal perspective, sending them an email to say, hey, Joe, I called you today at such time or this afternoon, still hadn't heard from you. We don't have a lot of options anymore. It just, again, puts it in writing as to what you may or may not have said in your voicemail, because again, you be careful how specific you are. Yeah, so hopefully that helps. All right, so we've got another poll question coming up. It's a little bit in fun, but so we're popping that up for you. So the real question is, how do you define how you collect money, right? But we would love your responses on there. So give us your vote on this. So which best describes your collection practice? Strict but kind, strict and uncaring, pleading for payment, or making the payment, or make the payment, or we'll come get you. So I know a few people who probably fit in all of those, right? So we got, y'all are doing a great job. We got 50% voted already. So while y'all are voting this, I've got a friend of ours and a client who I've worked with her many years. She's an awesome lady, but I'm gonna tell you, she'll cut you if you don't pay her, man. She's tough. So we got 60%. So we give you about 5 more seconds, then we'll turn it off and show you the results of that. So again, how would you best describe your collection practice? All right, so let's look at the results here. So we got strict but kind, 100%. Wow, man, I love that. That's really cool. I didn't expect
I thought
that.
We'd see some variety. But I
did too. Strict but kind, 100%. That's awesome, y'all. Congratulations. That's really good. Being strict, and I've said this before, you can call and say, look, this is business. This is just business. It's not personal. It's not trying to hurt you by any means. Just we're trying to get this collected. So there's nothing wrong with that. So tips for collection calls. This is not how you do it. Like, this picture does not define.
It doesn't usually work.
No, it does not work that way. Not very well, at least. So be prepared, right, and be specific, and looking for general excuses, right? Don't look. The check is in the mail. Yeah, okay. Well, how much? What check number? How much is it for? When was it written? And when is it mailed? You want to make sure that you get specifics on it, because more likely, we all know that may not be true for the most part. They're having cash flow problems right now, right? What's the response? I understand. How do we set up a payment plan arrangement today that can work for your cash flow, right? And a lot of people know this, right? Just getting that customer in a habit of making payment to you is a big part, right? If it's $100 a day or $100 whatever, right? I mean, you don't want to necessarily get in, and then it ramps up after that. Getting them in the habit of paying you is a great thing. Or they say, I haven't received the invoice yet. We talked about it earlier. Oh, no problem. I got that. Well, hold on the phone. I'm going to email it to you, right, while we're on the phone, or I'm going to send it by fax, or I'm going to make sure you get it before we hang up, and then we can talk about it to make sure there's no problem.
Mm-hmm.
That has been one of the best things of technology. And I thought people go, well, I don't have the invoice. Hold on.
Well, I'm not in front of my computer. I can't get my email.
Well, you got your, yeah, I bet you can. Yeah. Well, I'm going to send it to you, right?
You got a smartphone? You
right.
get your
There you go. So, and then know the facts of the account, right? When's the last payment? How much was it for? Did it clear? What's their credit limit? Things like that. It's just helpful in versus calling and not having any of that in your head, or not having looked at it, right? It takes just a couple minutes to get that in your head. And then think positive, right? Don't go in with a negative attitude, because I promise you it'll come back out, and that sort of breeds itself. But think positively, right? Also think about this, speak with authority, right? You're calling, and we've all seen the meek and mild, doesn't work, right? Have authority, you got a purpose, right? And be professional. As you all have said, right? Most of you said you're strict but kind. Being strict is not being rude. It's not being unlawful. It's just, hey, it is what it is, right? Know your audience, obviously. Connecting with your customer by name is so key. We had a client who I love this man so much. He's an awesome guy, and he's unfortunately retired. But Grady would call and go by and see his customers and call them by name. He'd show up at their office, right, to collect money. Mm-hmm. And Grady was one of these guys. He's going, hey, just came out, get a check. And he would stop. Grady almost always collected most of, if not all of his money. But he's a great guy. But he did it, and he was careful in what he said and how he said it, but he was persistent, right? He had a relationship. He called them by their name. Makes a big difference. The other thing, we talked about this in mediation stuff, but listen, right? Take notes when you're talking with them from the conversation. What are they saying? And a lot of times it's amazing when you call a customer and say, hey, look, call them for the payment. How do we get this thing taken care of? A lot of times, if they keep talking, you may not hear the first answer. It may, hey, look, I've just got cash flow problems right now. But if they keep talking, you may wind up hearing a whole lot more that really tells you the story.
Yeah, there's some debtors I've talked to who just go on, and you just let them.
Yeah. Because
you will find out so much information you otherwise never would have gotten.
That's right.
It's okay for them to ramble on for 20 minutes. Just make sure you're picking up what information might be valuable.
Yeah. And then same thing is get an agreement on the specifics for payment as much as possible. That's what we're talking about. When are you going to make the payment? When am I going to receive it? However it's going to be. Is it going to be check? Is it wire transfer? Is it ACH? Whatever it may be, right? You get the specifics of it. So, Jim, what are some things that we can say, right?
Yeah, so any fact about the account or the debt, what's the amount, or when was it incurred, what created the debt. So what did I buy from you guys? What machine did you repair? Or when did y'all do that? If you've got your file with you, you should be able to say, here's what it's for. We did this, that, and that on this date.
Right.
Sent you an invoice. The aging. So, how old is this debt? How is the bottom line number? How is that computed? And you can tell them, you say, well, this dollar amount is for this invoice, and then this dollar amount is for finance charges because you haven't paid me in 8 months. The last time you paid me was whatever date it was. Explain to them, why is it important to get the account paid? I think it's okay to say, and I think it's probably important to say, the longer you don't pay me, the more it costs you. So why would you not want to get this paid?
Yeah.
And then give them options to pay. Look, we got a credit card. We take a certified check. I can drive to your office and pick up a payment.
Don't go by yourself.
Exactly. Yeah. There's tons of different ways to take all their excuses away. Mm-hmm. Make it easy. The easier you can make it for them, the more information that you can rattle off to them. the less they can say, well, no, y'all didn't do this or that.
Right.
I can't get you any money because my bank's closed, or I maxed out my credit card. There's all kinds of arguments they're going to try to make, excuses. It's okay to help them.
Right. Yeah.
Helping them is really helping yourself, but in a way you're helping them because you're making it easy.
Yeah.
So it's okay if you know who you're talking to. It's
Right.
okay to verify all this information.
Yeah.
I think that's another thing you just got to keep in your head is like, who are you talking to? And once you know that's an authorized person to talk to, you can provide anything
Right.
about the account.
Yeah. And just keep good notes, right? That's a huge plus, right? So we talked a little bit about what should you not say, right? How about threats? Does that work?
Let's don't threaten anyone. We talked about the criminal stuff. Talked about kind of bullying and, I'm going to do this or that.
Right.
You don't want to threaten. It's okay to say, we are considering all of our legal remedies. We're thinking about sending this to legal. That's not really a threat. It's okay to say something like that.
Right.
Harassment, again, that's calling them 50 times a day.
Not a legal definition,
Yeah.
but what you don't want to do, I would say in front of a judge sees emails or sees correspondence where you were just wearing them out, right? Probably doesn't make us look that great.
Yeah.
Or if you say, I'm gonna shut down your business and take your family or take your kids or your dog or whatever, probably not the greatest emails. Is it against the law? No, but it doesn't look good, right?
Yeah, I mean, there's a difference in saying we're going to pursue all legal remedies, and I'm going to take everything you have, and take you to the
That's
cleaners, and you'll never do business here again, and that kind of thing. That's not going to get you anywhere.
One thing we were thinking about trying to put in the slides and didn't know how to say it, but I think we said it verbally, and that is, if you are getting frustrated with dealing with this customer, let someone else know on your team so they can help and or communicate with that customer. Don't lose your cool with the customer. It's just not worth it, ever, right? Call us, we'll take care of it for you. And I haven't broken any knees this year, have you?
Try to get some knuckles, but no knees.
Okay. That's not unprofessional.
I don't think I've been yelled at this year either, so it's hard, and it's March, so we're in good shape.
And then obviously no details on the voicemails, emails, or texts that we talked about, right? Unless you are who you're communicating with, right? So we had one of the questions I want to make sure that we hit, and that was in regards to cash sale transactions. If someone has a cash sale, they come in, deal with you with a cash sale, and for some reason they don't pay, can the collection team call them, go after them for the payment? Absolutely. You still have a contract. It was just not really well taken care of, but you still have a contract, right? There's a promise to pay once you give them or they receive whatever you're selling them, and they just for whatever reason didn't pay you. You still have a reason and an ability, and lawful can go after. Does that make sense? So hopefully, if y'all got other questions, let us know. But hopefully that makes sense. So again, if you've got a question, you can submit it to us either by email or on the webinar. We really do hope this is helpful to you. It's been fun for us to go back through this, and again, special thanks to our friend and client Mark for this topic. We really hope it's helpful. If you later on have a question about any of this we've covered, please call us. We'd be glad to help you with that. And again, thank you so much. And we hopefully will pick a topic that if you've got a topic that you want us to cover on April 15th, let us know. We'll be glad to consider that and put that in the hopper. So, Jim, good seeing you, man.
Yep. Thank y'all.
Y'all have a great day.